This second video, we are going to deal about the second case, Union of India versus Shivraj. In this case also, the Section 5A was brought into picture of Land Acquisition Act 2013. The facts of the case was that the respondent was in possession of 50,000 bighas of land, which the government has notified in its which the government has notified under Section 4 of 1894 Act for the public purpose, and the public purpose the government has given for plant development, that is the industrial development purpose. The High Court, although the High Court has quashed the acquisition proceeding, by giving the reasoning that the proceeding was not proper because it was in violation of the natural justice. Because the landowners was not given a proper opportunity of being heard, and furthermore, in the case of E.D. Hijra, in the case of E.D. Hijra versus the Secretary of State, the Calcutta High Court was unable to grant any relief to the owner of property because under the old Act of 1894 there was not a thing like Section 5 clause A, which talks about the objection clause by the owner of the land. So the Calcutta High Court denied any relief to be given to the landowner, although after that the amendment was made and Section 5A was inserted in that act. Now coming to one very important thing in this case law, that is, just a second, that is about natural justice violation principle. How the natural justice, in the context of this case, what is the meaning of natural justice violation? Just we'll try to get through an example that Collector A heard the proceedings. He got transferred to other place. Collector B got appointed into his office. Okay, and Collector B made a report for recommendation to the government, and that very report was invalid because it was the violation of natural justice. How it was the violation of natural justice? Because the Collector A has heard the proceedings, but the Collector B comes and directly prepares a report and give it to the government. Means the parties, the landowners, the tenure holder of the land didn't got an opportunity to be heard by the collector. So it was a violation of natural justice principle. This thing has been let down in the two cases named Automotive Tire Association versus Designated Authority and Balakram Gupta versus Union of India. We will come to these two cases. First one is the Automotive Tire Company case. Automotive Tire Company case, in this case the final order was passed by some third collector who got recently transferred to the town, and the two predecessor collectors who heard the hearings of the case were transferred to some other place, and the third one comes and instantly passes an order or gives a recommendation to the government. So it was also in the violation of the principle of natural justice. The person accords hearing must submit reports. In the case of successor officer, decide basics hearing. Predecessor, the same thing, that any successor officer comes and he cannot give a report vicariously or something like that. Another case was, I think, another case was Balakram versus Union of India. In this case also the Delhi High Court quashed the proceeding only on the ground that the objection was heard by one collector and the another collector passes the order. Furthermore, in the case of Nageshwar Prasad versus the state of UP, the nature of objections was dealt. Which type of objections were to be taken, it is dealt. The most important thing in this case was laid down that the authority has to consider the objection under Section 5A. Under Section 5A, the objection which were filed by the tenure holder, means the landowner, must be considered by the authorities, appropriate authorities. Uh, and the same thing here, it is also written that under section 5A, the statutory embodiment, audi alteram partem, must be followed. And one thing important is the objector must also give some some the objector must also give some basic reasons or some strong reasons for in their support that why their land should not be acquired. And basically the objector has to convince the collector that by giving their reasons that why their land should not be acquired. And furthermore, in the case of one more thing, under Article 300A, it gives a paramount authority. It is a paramount authority which gives the validity to Section 5A. Okay, so Section Article 300A of the Constitution is giving authority to Section 5A for its constitutional validity. And again, the same thing, that section 5A is a substantive right. Substantive right means the right given by the law, which can be taken away on the grounds of good and valid reason. These recommendations supported by the valid reason should and should not be acquired. Reasons must be valid. Now some more cases in this relation. The Gallapalli Nageswar Rao versus the Gallapalli Nageswar Rao case. In this case, the personal hearing, the personal he- this case the personal hearing enables the authority to closely watch and the demeanor of witness and clear the doubts. What is demeanor of witness here? Demeanor of witness means वो विटनेस कोर्ट में उसका क्या हाव भाव है, वो किस तरीके से बोल रहा है. Demeanor of witness is was observed in order to know that whether the witness is stating the false evidence or he is stating the true evidence. Means demeanor of witness fixes the strength of witness in the court or the weakness of a statement given by the witness in the court. In further case of Rasid Javed versus a state of UP, it was laid down that the deciding authority must decide the divided responsibilities also. And in the case of one more thing here, that it is basically a revision. We have dealt in the previous case also that the state government deposits the amount of compensation in the state department, but this is not valid in the eye of law for giving compensation to the landowners because it was not deposited before some appropriate authority or appropriate forum. It was deposited in the government treasury, so it is not holds a validity in the eye of law. The case of Anglo Fernandez versus the state of Goa. In this case, the depositing compensation in a state department doesn't vitiate the liability to pay interest on it. Means if the state government deposits the compensation amount in the state fund or the state department, it doesn't vitiate the liability of a state government to pay the interest over it to the landowner till they get the compensation. Okay. Now there is a case in relation to the vitiating the proceedings, means vitiating the proceedings of land acquisition. Bharat Kumar versus the state of Haryana. Section 24 clause 2 is beneficial provision. In this case, there are 2 points. Point number 1, the physical possession was not taken by the authority though the award was passed. Second point, that the compensation not been made or deposited before the appropriate forum, then the proceeding must vitiate. In both two cases, the proceeding will get vitiated. And we have dealt this Delhi administration case also. So the final conclusion of this case is that therefore the objection hearing not requirement section 5A means hearing the objections is basic requirement of the government to pass an award. The mandatory language of section 5A is clear that the collector who here must also submit the report, and then only the report is valid report. Means under section 5A the collector is duty bound to listen or consider the objections of the landowner, and thereafter he should make the report and submit it to the appropriate government. That report will be a valid report. The collector who hears the proceeding must submit the report. This will be a valid